Hello, my name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. First, we hope that you and your entire family are remaining safe, healthy, and secure during this ongoing coronavirus pandemic. I want to assure you that Ira Smith Trustee and Receiver, Inc. remains fully operational. Both Brandon Smith and myself are available to meet with you at any time, either over the telephone or video chat. We are holding all meetings that way. So if you have any questions at all about this Brandon's blog or anything else, feel free to shoot us a message, give us a phone call. We would love to hear from you. Today's Brandon's blog, Brandon wrote about Evander Kane contract. Can an involuntary Chapter 11 bankruptcy unveil indentured servitude? Now, Chapter 11 is the reorganization section under the U.S. Bankruptcy Code, which is the United States bankruptcy law. Brandon previously wrote in January about the Evander Kane bankruptcy. And there's been a interesting and startling new development. So I hope you can watch until the end of this video, because I know you will get value from it. So down below, Brandon starts off by giving a bit of the history of Evander Kane's bankruptcy. Evander Kane, of course, is the forward on the NHL San Jose Sharks team. Right now, he's the second leading scorer on the team. He had to file for bankruptcy, mainly because of gambling losses, plus some other issues that Brandon describes below. And he had filed for voluntary Chapter 7 bankruptcy, which is the U.S. equivalent to the Canadian filing an assignment in bankruptcy through a licensed insolvency trustee. 5 financial institutions that Evander Kane owes money to filed a motion in court to turn his voluntary Chapter 7 bankruptcy into an involuntary Chapter 11 proceeding. Why? As Brandon writes, if it's turned into a Chapter 11 proceeding, then the Chapter 11 bankruptcy trustee will be able to grab his NHL contract, which has 3.5 years left to run at an average annual salary of $7 million. And the Chapter 11 trustee could even grab up to 100% of all the money left to be paid without any accommodation for Evander Kane's living expenses if it's shown that that amount of reorganization funding is appropriate given the amount of the debt. In response, Evander Kane filed a motion with the court to say that the application by the banks, if successful, to grab the money from his contract and potentially all of his money is the same as putting him in indentured servitude, and that violates the 13th Amendment of the United States Constitution. The 13th Amendment, of course, is the one that bans indentured servitude and slavery, and also has researched the differences between indentured servitude and slavery and describes that. In essence, the people under indentured servitude or slavery are treated the same. The only difference is those under indentured servitude signed a contract to be indentured for a 4 to 7 year period, is what American history tells us, in return for safe passage to the U.S. room and board. Brandon also describes why and how indentured servitude morphed into slavery in the United States. That aside, the Evander Kane motion about being akin to indentured servitude if the financial institutions get their way is somewhat outrageous of a claim and may not be successful, but it isn't unprecedented. Back a few years ago, the rapper 50 Cent, who went into bankruptcy and whose creditors tried to get him into involuntary Chapter 11, made the same argument in court. Now, 50 Cent and his creditors ended up negotiating a mutually agreeable settlement, so the issue in court was never heard. Brandon found a second case, which is an appellate court case, which was just issued earlier this month, where the appellate court said, although the debtor, the insolvent debtor, who made this claim didn't yet have standing to make that claim, can make that claim once they do have standing, which would be under the motion in the lower court to actually put him into involuntary Chapter 11 bankruptcy. And Brandon describes that court case below. So that hasn't yet been tried. So we highly doubt that Evander Kane wants to either void his San Jose Sharks contract under Chapter 7. However, the Sharks have advised the court that that could be a possible outcome of his bankruptcy. And we doubt very much that he's going to want to force the court to make a ruling on his motion that it would be akin to putting him into indentured servitude. But all this jockeying is probably to try to get a mutually agreeable settlement, just as was the case in the 50 Cent bankruptcy administration. So it's a fascinating situation, one that is probably more tailored and suited to the US bankruptcy system than the Canadian bankruptcy system. But it's not impossible that someone in Canada one day may make that argument. So I invite you to read the entire Brandon's blog because the details are truly fascinating. Again, we hope that you and your entire family are remaining safe, healthy, and secure during this ongoing coronavirus pandemic. Ira Smith Trustee and Receiver Inc. is fully operational. Both Brandon Smith and myself are available to meet with you by telephone or video meeting. So if you have any questions at all about this Brandon's blog or anything else at all, feel free to shoot us a message, give us a phone call. We would love to speak with you.